I'm going to introduce Barbara Gardner, and I've known Barbara about 30 years, and she has practiced mainly employment law, both in Texas and in Kansas. She graduated #1 in her class, and one of the neat things about Barbara is at one time she was a rock and roll singer.
Yeah.
And still rocks and rolls, and board certified. And I think probably most of the people here are either Democrats or leaning that way. And I want to call your attention to the fact that Barbara is our candidate for the 234th Civil District Court, and will be on the ballot in 2014.
Thank you.
Barbara Gardner.
All right. Thank you, Bob, for that nice introduction. And I also want to thank Bob for putting this seminar together. He and his staff have worked extremely hard. They have good sponsors. This is amazing. This is a Cadillac seminar for almost free. For you all to come to spend the time, you're getting a lot of substance. Bob asked me to talk about some practical things. So for a lot of you I see who are very well experienced, I see Jim Peacock, who's also running for district judge. Of course, Judge Chris, who's a judge herself, that's going to run for state rep. A lot of you all know maybe what I'm about to say, but I'm from East Texas, and my brother used to do a lot of hunting, and he said everybody hunts their dogs differently. So I'm going to tell you how I hunt my dogs. And I have practiced 32 years, and I love trial work, and I think performing on stage helped me to be a good trial lawyer. I like the attention, but I like being with the jury. So you want to get to the jury is what you want, without being dismissed and thrown out on summary judgment. I started out with Mandel and Wright, who that law firm did a lot of maritime work, and I worked on a big case with Rick Schechter years ago, back when I was doing forklift cases. I used to say we're 30-year lawyers. Put me in a room for 30-day lawyers, I misspoke. Put me in a room for 30 days and I can build a forklift. So, and I want to say to David too, that 1983 burden of proof, I've tried those cases. Those are worse than gross negligence. It's not even deliberate indifference, it's I don't give a whatever. And they're hard, so I commend you too. But what I've put together here for you in narrative form is practical suggestions, because as you know, if you win a trial, you're destined for appeal. And the defense lawyers say the trial is a bump on the road on the way to the appeals court. And they will find something. They will look and find something to reverse you on. I had one case against Dow Chemical that my client was dedicated, I was dedicated. We spent 11 years bringing them to their knees and went to the Texas Supreme Court twice. So you have to have the staying power, you have to have the money, and it has to be a big case. So most of the cases I'm talking about now are the above 100,000. I'm going to speak to that in the end of the program if I have the time. You'll know the Rule 167 and Rule 190.02 that became effective March 2013 this year really hits hard on the 100,000 and below. So I'll get to those later. First of all, I want to say, when I first started out as a young lawyer, gung-ho, I want to win everything. So I just did so much of everything that it was more than the case was worth. They said, slow down. So if you have a small case, I put in some practical suggestions. If you can settle early. Of course, the defense lawyers know when you have a small case. And I'm going to give anecdotes. They're not war stories, but to demonstrate what the problems are. And Mandel and Wright, we tried a lot, and we took everything. We took a lot of soft injury cases, and people want to take premises cases these days. We take them all comers, and so long as they're good on the merits. First, the merits are the important thing. But if they know you're $100,000 less, they'll run you around the bend. They will not give you the time of day. They will force you to do all you have to do. And so, as you know, in Colossus and some of the other software programs, you want to be clicked on their software as a trial lawyer, not a settling lawyer. You get more value. Maybe you know that already. But still, the small cases are difficult. But if you have a good paralegal, we had one of the finest at Mandel and Wright, which we changed the name in 2004 to Tucker Barnes. And then another idea, if you get too much money in the case, the insurance companies won't settle. You get too far down the road, they've already spent the money. But another thing that I have there at page 1 is manage your client's expectations. A lot of lawyers, and I don't know why they do this, they take in cases, go, I can get you money, I can make you rich, I can do this, I can do that. We've had clients, and what I do with them, I bring them in. We had a big maritime case when I left downtown in December, and he didn't speak English very well, so his brother was his interpreter, advisor, but he was sort of the case director, I think, self-appointed. But so I would bring the client and the brother in, and one thing I suggest is maybe the spouse, whoever is talking in their ear at home, and get a big chart of paper and write down on the right side, the left side would be for you, the items that you have to prove and how you're going to prove it. You have to educate them on what the problem is. Most of them think, I can't work anymore, I want a lot of money. It doesn't work that way. So you teach them in a very elementary fashion what we've got to prove, and then I draw a line down the middle, which is causation. Yeah, but you got to prove that the other side did something that's illegal. And in employment cases, a lot of times I get calls, 2 or 3 calls a day. It's unfair, it's mean, it's maybe immoral, but it's not illegal. So the other side has to, and of course negligence, you want to try that in a 905B case, that's what this was. But then they have defenses. You have to do away with the defenses, and then there's this third party, responsible third party. They always find somebody who must be responsible, not me. But you explain all this, and then you get down to the damages, and then you give them, and I always try to work up the damages, what wages they've lost, what future wages they might be able to recover, and that's a big might, and then maybe that esoteric question mark on intangible losses. Then they understand and they get the idea of the value of the case, and it's not a $5 million or $10 million case. It might be an $800,000 case. It might be a $200,000 case. But you date it. Keep that chart. Because as you get closer and closer, the client wants more money. We want to go to trial. Well, they don't have anything invested. A lot of times the clients that you represent don't have any skin in the game. Now, I am fortunate enough in employment law, I insist that they pay the expenses. Because usually they have a spouse, or they may have some money, and they're not, they didn't lose 2 legs when the forklift fell on them. But if you have some client that has the skin in the game, that's better. One thing I do on contracts too, by the way, is, and I learned this in Kansas City, is on expenses. I have a section, and this is good with the ethics opinions that I've read, to have a blank. I can pay so much per month toward expenses. Let them take it home, let them talk it over with their wife or whatever, and they'll fill in sometimes $100 a month. I had a welder who paid $100 a month, 2 or 3 years, and it helps. I mean, it helps on your depositions on the small cases. But I've finished 15 minutes of page 1. I could talk a lot, but let me move a little quicker. As I said, the defense lawyers know when you have a bad case. I remember one time I had a small case, and they wouldn't offer me a dime, and it's like a little, rear end, or my neck hurts when I was a beginning lawyer. And sure enough, the defense lawyer had something that I didn't have, and the jury poured us out, and I wanted to get under the table. It is so embarrassing. So if they're not offering you any money, there's something going on. You need to find it out. And I believe discovery is the place where you win your cases. These days, and I said, don't take a bad case. Sometimes you don't know it until later. Some lawyers will take a case, sign them up right now, and then go do their investigation and then find out they can't win it and they definitely can't settle it and they try to just give it back to the client. I really personally believe that's not fair to the client. What I do, and I did in a big case that I won with in Judge Hittner's court, there was our client was short and blonde and just cute as a button, and she wanted a promotion. And the president of the university said, in the presence of the dean, that position is earmarked for a different ethnicity. Well, I called up the dean, and I remember I was in my dining room that night. And she said, I've got a lawyer, and yeah, I will talk with you. And we went to trial, and yes, she did. And they fired the president. And we won a bunch of money. But do informal discovery to find out if you have a good case. And if you don't take it. I mean, it just goes from bad to worse. The best time in your case, you've heard this saying, is when the client walks in the front door. And they'll keep things from you. I tell my clients, I need to know the good, the bad, and the ugly. I need to know everything so I can help you. They think if they keep things from you, that maybe it won't ever come out. I say be thorough. Now, again, you have to balance your time, but you have to know that the defense lawyers have all the documents already, especially in employment cases. They have most of the witnesses. I had a case against Brown and Ruth that I went through, I'll bet 25 people. I said, oh, Ms. Gardner, I wish I could testify, but I have a wife and 2 children, and I just can't help you, and I'm not going to lose my job. I found one guy, and I believe everything's on the bell curve. He said, yes, I was there, and yes, I saw what happened, and yes, I'll testify. And we won. But be thorough. Go through all the people that you can that might know something. Now, I'm on subsection 4. I think the most important thing in the beginning that a lot of PI lawyers that I've seen over the years don't do, because negligence is, hey, that's easy, you know, you did something you shouldn't have done, or you shouldn't have done something that you did do, or what have you. But start, and I was taught this at Bracewell, start with a jury charge. Know what you have to prove. And I tried a case with Don Kidd and Jim Perdue in 2009, and they follow this rule. I don't know, they're probably not here, but they're just preeminent trial lawyers. They're very good. But get in and get out. Don't ramble around. Also, in the very, very beginning, I go research the landmark cases. This is at the beginning of the trial. I put them in a research folder, and then during discovery, I extract those words from the leading cases into my deposition questions, into my request for document. You're now putting your appeal record down, because you know if you win, you're going to be appealed. So you have to have, like in a premises case, oh, so you couldn't do this the way you wanted to do it. You had to follow what the premises owner told you to do. Is that what you're telling me? Oh, okay. So you try to get those cases and have them worked into what you're doing from the very beginning. Now, I think paper discovery, notwithstanding Rule 167, is still the best way to go. I will say, though, that there are some very good lawyers, Jan Fox being one of them. She is out the gate with a deposition, first thing. Now, when I did maritime law, Royston and Razor always did that. They want to take my plaintiff first, right now. And that's a good thing, because before the theories all get crystallized and the lawyer figures out what's really going on, you can get the truth. I have a saying, sometimes the truth slips out. And that's where you win your cases, when you really get down to what happens. But on the whole, I have gotten better results over the years through getting documents and studying them. Now, what will happen, you'll get a truckload of documents. So hone in your requests and study them when they come in. You'll have a inclination to want to put them in the folder, in the file, and get to them later. Don't. Study them then when they come in that day, the next day, that weekend. I had a case years ago when, and I believe this was an accident, Baker Botts was on the other side, and they're very thorough, and maybe they're just very honest too on this case. It was Chapman Smith, and he is a good lawyer. I had a law firm from Dallas opening a Houston office, and so they hired my client, who was a female, to do real estate lending. And after she'd been there a little while, they bumped her out and put a guy in. And sure enough, during discovery, and it was a gender discrimination case, there was a memo. Why aren't we interviewing a man for this position? Sometimes, just occasionally, you'll get a smoking gun. So read. In fact, I'm going to compliment Dodd Kidd on this. This last case that we tried together in 2009, and we got a $10 million verdict on a premises case. They were, from the very beginning, refusing to tell us who owned the property. Now, that should make your knee jerk. If the other side is being resistant, they're hiding something. They are. So keep digging. Sure enough, in one of their documents, Don found just a statement of one of the 25 subsidiaries owned the buildings. And of course, we learned from HCAD that BFI owned the property. But read those documents, study them, go back and reread them, and you will find things in there that you didn't know were there the last time. Now, in depositions, I have about 6 more minutes here, so let me skim through these. Again, taking an oral deposition is an art. I think you should study again. I'm very dot your I's, cross your T's, overly thorough. So maybe it's not cost efficient on the small cases. As I said, my supervisor, Cliff Gunner at Bracewell, said, stop, you're now past the damages. And the fees I was charging. But when you do your outline, incorporate those magic words, but listen. Just like you're sitting right there with the deponent and you're the only one there. If they get off to something new, go with them. A lot of lawyers don't listen. Go with them and trace down that, and you might find something, and I've done this several times, that the defense lawyer didn't even really know. But listen, listen, listen. That's hard to do. Now, subsection B on corporate depositions, again, I will give a credit to Paul Gold because he's talked in this a lot about taking corporate depositions, and what interesting thing in his paper, and you can find it probably online, that if the corporate rep says something like, I don't know, that's binding. The defense lawyer can't come back and trial with a new theory. Whatever is said by that corporate rep on behalf of the corporation binds the corporation. So read that paper. It is excellent. Now, in deposition on written questions, people think this is just for medical records. It's not. I have gotten witnesses from North Texas in small cases, and I'll find them and talk to them and get to know what they know, and then I'll even send them a draft of my questions. We'll hone down the answers, and then I'll serve a deposition on written questions. Read them at trial. And that is very cost efficient. Also, telephone depositions, and I'm a little still skeptical of teleconference depositions because I did have one once where when I would ask the question and I didn't travel there, but the defense lawyer did, if they go, you go. Because there was a little pause, and I was thinking I was hearing ruffling paper. The defense lawyer was sliding notes. And I was at home because I wanted to save money. Well, that doesn't save money, you lose your case. But I did have a telephone deposition once where in an employment case, I had a real key witness in Hong Kong, and I got to know him, and I'd stay up till the time I could call. And sure enough, set up a deposition by telephone. Great deposition. We settled the case. And after his deposition, he called and he said, how'd we do? He was really invested in the case. So you can save money on those. Now, going on down to the end of page 5, summary judgment proceedings. In employment cases, you can plan on a summary judgment motion. Years ago when I started in 81, it was the motivation why someone was fired was a fact issue, always. Now, the Fifth Circuit and the Texas Supreme Court have taken it just way to the other side, so plan on a summary judgment motion. And what I say is thank you very much. You've now focused me. Now I'm going to teach the judge what this case is really about. And by the way, there's writings these days you've been reading maybe. Don't start with the good stuff. Start with how mean and bad the other side is. Start your summary judgment facts with how dirty, rotten they have been. And what I learned from a very good writer in facts, you start with fact, 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 and when the reader finishes reading the facts, they're convinced. You don't even need the law. The facts are what will do it for you. So you're very persuasive in facts, clear facts. And that's Bill O'Connell, by the way. He is since retired, but he was had a journalism degree, was with the Houston Chronicle, then had his own practice, but he was the editor for the ABA Bar Journal. So I learned a lot from him. Adverse witnesses at trial. Oh, I forgot to talk about who you don't depose. Once you get some documents that are so darn good, and it's a key witness, remember that in depositions you teach the other lawyer what you're up to by your questions. That's why you want to get in and get out. Don't ramble around asking everything. I've seen lawyers come to depositions, they just start asking questions like they're learning the case. Don't do that. I learned that from very good lawyers at Bracewell. Outlines, exhibits, highlighted, I mean everything, you know what you're doing and you get in and get out. But if you have documents that nail them to the wall, like we had a premises case where the convenience store manager supposedly didn't know anything about the car wash that had a defective grate that no one could see, and it was dark inside there. But we had records from their computers showing him in there about every third day of the week. So I didn't take his deposition. I'm going to subpoena him for trial as an adverse witness. And for employment cases, I try as many people as I can in my case in chief. I put adverse witnesses on so they can't do it. I get to them first, and they don't have too much left to do. Now, smart lawyers can get around that. They'll send, I had one against Exxon, and that was back, I'm going to say, when I was much less experienced, and I waited to issue my subpoenas, and they sent one of the key witnesses to Florida on some project. Couldn't get him subpoenaed, didn't do a good job in the deposition, so you need to really plan ahead on your trial. That's why these depositions are important. But try to get as many adverse witnesses, in my experience. So again, you have taken the defense lawyer off guard, and if they're not as thorough as you are, you might know some things that they haven't studied. In fact, the big firms, I know I started at one, the senior lawyer doesn't do anything. He's doing, you know, big stuff, policies and, you know, political things. The senior partner under him will be showing the video depositions at trial. The junior partner is still back at the firm, and the associate who did all the work is still doing all the work on something else. So a lot of times the person trying the case might not know nearly as much as you do because you started in the beginning. You did it, you lived it with the client, you're ready for appeal, and you know more than the senior lawyer who just waltzes in to try for a case for the trial. But my primary advice is to know your legal points, because you know a good verdict is going to be appealed, and be ready to go. That's all I have to say. I will talk with you afterwards. I know Bob's keeping good time on this. I left downtown, and I have some of my cards now. I went to Lamb, Lynn, and Phillip to set up an employment practice for them. But my passion is to become a judge. I think judges should follow the law. Don't you? All right. Thank you.
Thank you, Barbara. In that handout, in that black bag, is her article, and she'll be around for a little bit. She's running for the 234th, and so remember that at the time that election comes.